One of the most common questions we're asked is, should I sign this severance agreement? If you're in a position where you have received a severance agreement, first of all, let me say, I'm very sorry for your job loss, because believe me, we see over and over and over just how difficult it is to deal with this usually very unexpected and shocking loss of a job. So you have my condolences, but I can also promise you, from working with hundreds of clients who have lost their jobs, it will get better, and probably sooner than you think. So when we are discussing with potential clients a severance agreement and helping them to decide whether or not to accept it or try to bargain and negotiate for more, we look at a few things. First of all, most importantly for you, is what is the amount of severance pay that you're being offered? Because in exchange, what the employer is going to want you to do is basically waive all of your rights to sue the employer for anything the employer did to you. So the severance pay offer, we look at, when we're determining how decent of an offer you're receiving, we look at things like the length of your employment with this company. The longer you've been there, obviously, the more we would expect them to pay you in severance. We look at your salary. If you happen to have information about other employees and what they have received in severance benefits, then that's helpful information as well, because if you are getting offered much less than you know other employees have received, then that gives you an area to explore for further bargaining. Now, typically, these severance agreements have confidentiality clauses. So if somebody signs a severance agreement, they're not allowed to talk to you about how much they were offered, and in some cases aren't even allowed to tell you that they got a severance agreement or signed a severance agreement. But in some instances, you may find that information without breaching a severance agreement, and that can be helpful information to have. Another thing that's very important when we're evaluating how much you're being offered and whether it's a fair offer is the reason for your termination. Is there any indication in our mind, and from what you tell us, that this termination is a result of retaliation for having complained about, for example, sexual harassment, or for having complained about race discrimination in the company? Is it retaliation for you blowing the whistle on improper financial auditing practices within your company? These are things we would want to know as well. Are they getting rid of everybody who is over the age of 50? That's something else that's incredibly important to know, because those kinds of things can give you significant leverage in the negotiating process. But it's not just about money. You also have to keep in mind, when you're thinking about signing a severance agreement, about what else you can get through that agreement. For example, it could be very important for you to get a letter of reference for the company, because very often employers will not want to give that kind of information. If a potential new employer calls your previous employer to find out about you, they'll usually only get the dates of your employment, maybe your job title, and that's it. The employer who fired you won't tell them whether you're a good employee or a bad employee or anything. So you might want to negotiate to get a very positive letter of reference written by somebody who still works there, who you still respect and who knows your work. That's something we could negotiate for you as well. Another issue you may need to consider is whether you have a non-compete clause or a non-solicitation clause. These clauses are very common in professional employment situations, such as doctors or technology or sales, where you have signed an agreement earlier in your employment that says that you promise that you will not compete with your former employer for usually a year, sometimes longer, doing the same kinds of work that they're doing. The non-solicitation clause is you promising that you will not try to poach your previous employer's customers or perhaps their employees to start your next business or your next job. So we can help negotiate those clauses as well, and if you've signed them already, they're already effective against you. But this severance agreement can alter any of those if you are able to negotiate that. It's a new contract. It can change the terms of your existing non-compete and non-solicitation clause. So it may be that the money that they're offering is fine, but you have other things that you need to change in that severance agreement. It's obviously far more complicated, and there are far more unique variables in your agreement than we can cover in this short video. But I encourage you to click on this link if you want to get more information, and we'd be happy to discuss your severance agreement. Even in just one consult, you may get all the information that you need so that you can negotiate that severance agreement for yourself. Thanks again for watching, and if you want more information, just click on that link.